What's going on, everybody? This is Lady Luck here again. Okay. I told you all that I was going to be posting up some content today. I just did a video. It's a long one, but it's a good one. An epic courtroom hearing where the judge just delivers a good punch, brutal smackdown against super stupid and incompetent ass attorney Max Solomon. Steven, whatever. I don't care. And it's epic. It's a long video, but it'll be great for podcast listening. You're driving, you're in the car, you out there hanging out, you take a shower, you get ready to go to bed, ASMR, however you want to put it. It's great listening for that. And it's basically, it was on Jedediah's live stream. I call him Bishop. Bishop did a live stream where his team was able to get the get into the hearing regarding super stupid frivolous lawsuit against Dalton Park District for basically having a meeting. I mean, it's so many moving parts to that, but the council representing the Park District filed a motion on a Court Rule 137 asking for sanctions and attorney's fees and court costs and stuff. And the judge decided to give a severe reprimand, but he is going to force an order, super stupid and Max Solomon, and he who will not be named in the Lady Luck Club to pay attorney's fees and court costs. How he divvies that up is going to be determined on, I want to say, at some point between March 18th and March 20th. But that case is going to be very interesting to hear, and the fact that they actually think that they have a case in the first place is just baffling to me. Every time something happens, Super Stupid doesn't like it. Her and her dumbass goons, the two you see here, Keith McChicken Nugget and Michael Smith, always want to hear and say something's illegal, while neither of these two clowns attended law school and can actually give a legal argument as to how it's illegal. So I want to check this video out. This is part of the interview that Bishop did with Biggie Size McKeith and Michael Smith. And he brought these clowns on his platform. I'm just going to tell it like it is. He brought these clowns on his platform. But there's a specific segment of this that I'm going to play because Michael Smith thinks he knows how government works. And somehow someone had him falsely believe that he knows the law when he doesn't. And then I'm going to go to the election board hearing that occurred where Michael Smith, the dummy, decided to testify and then got his ass handed to him epically on a silver platter because he's not that smart and he's not an attorney. So they want to object to people trying to run for mayor in the village of Dalton, but they don't even know how to file it with the court properly. There's clear laws that express how certain pleadings and documents should be filed. And yes, there is a such thing as a timely filing limit, meaning you got a certain number of days to file your objection. And that objection needs to be based on the law. Well, since these two goons don't know it, of course it didn't go the way they wanted to go. We're going to get to that election board hearing, but I want to play this first so that you can understand why I have zero empathy for the Big Mac Happy Meal and Michael Smith, who knows nothing. Good grief. So let's get to it.
Although they might have issues, I deal with facts and law.
Because somebody told him that he was smart.
Off the top of their head. They don't understand government.
Who?
A lot of people don't understand government.
What?
And I've asked legislators because
funny he thinks that.
Official, all you gotta do is be 18 years old. Be
wow.
president for a year. You don't have to have a degree. You don't have to have a high school diploma. That's it. They need to change it like the school board members. In order to be a
What?
school
No,
board
they
member,
don't.
you got to take credits. You got to get credits in finance. You got to get credits in.
So obviously, you do need to have some level of understanding, because hearing that come out of your mouth does not seem like a bright idea to bring on someone that only has a high school diploma. As a matter of fact, I'm going to go so far as to say this. You need to have a law degree, or at least a paralegal certificate. You need to have some basis and understanding of the law and of politics. You need to know that there are 3 separate but co-equal branches of power in government on every level. And I can guarantee you, Michael Smith does not know that. I don't care what he claims to know. He doesn't know how the law works or how government operates in the slightest bit. He says things that are so contradictory. But okay, I'm going to just... This is like a 5-minute video. I'm going to let it play out. I recorded just that segment of it because I wanted to lead this into that election board hearing, which is epic. So we're going to get to that right after this. So just hold on, because this is about to get really dumb with these two. And then I'm going to show exactly why I am so happy they got the brutal smackdown they got in an election board hearing where they were trying to object with no premise based on the law because they don't know it.
Let's get credits in that. That's what you need, because a lot of people are running for these seats just to have them for the little type of money that you get.
Oh, funny how that super stupid is doing the same thing.
Of residents.
Yeah.
And
exactly what super stupid is doing.
On the government aspect. You know, a lot of people don't understand that, in fact, the mayor is the CEO.
What?
They run the day-to-day operations. As a trustee or alderman, we don't get involved in that.
What?
Our job is only 2 things: to legislate as well as to deal with the budget. That's it.
So what's...
So he knows nothing. The legislative board are the ones that are supposed to help write and amend the laws that govern how it operates. So how can you say that they have nothing to do with the operations when they're the ones passing the municipal codes or the rules to determine how it operates? This is how buffoonery, the buffoonery of this and cartoonish he is. To say they have nothing to do with that, but they pass all the rules and municipal codes that determine how it operates. She is just 1/3 representation and nothing more. And she's learning in a very epic way. She doesn't get to override that judicial branch no matter how hard she tries. And she's not going to override the legislative branch because no one owes her that. This is not a dictatorship. Get the fuck out of here. This is a democracy. And if the board says we're going to veto you with the majority vote and we have the power to do it, they're going to do it. And I expect them to do it. She is out of control. This is why the village of Dalton has a damn deficit, because these 2 goons don't know government, laws, or math. And neither does she. Super stupid, when is the last time you read a book? Cite one. And it better not be Dr. Seuss. If it's I do not like green eggs and ham, I'm going to lose it. Get your bum ass out of here. She can't do simple math. She keeps lying about a surplus, but won't present invoices or financial disclosures and receipts. What the hell did you buy on Amazon again for $40,000? What did you get at Wayfair again? Because see, here's the thing. Michael Smith is not smart enough to know that the FBI has subpoena power. So whatever you think you hiding by not presenting this information from the village of Dalton, understand that the FBI will just simply subpoena the stuff from Amazon and Wayfair. They're going to get those itemized statements. They're going to find out what the hell you bought. Because they're not smart enough to know that this is a part of their soon-to-be reality. And what the hell are they defending her this hard for? What do you two have to gain out of this? What do they have to get out of this? What are they gaining from giving this high level of defense for someone that's under FBI investigation. Like they're going to override the FBI. Y'all not even smart enough to add 2 + 2. This is the insanity in all of this. So at some point, they're going to disconnect themselves from her either way. Why not just do it on your own voluntarily? This is what happens when you have when you have useless, stupid buffoons in your inner circle, because you got a narcissist that wants to be the smartest person in the room. She's got to surround herself with people who are dumber than she is. And Michael Smith and 2 cheeseburgers and a large fry is the perfect example of that. Useless idiots. That's exactly what they are. For fuck's sake.
Thaddeus Jones' report, or Thaddeus Jones' ruling is that the sitting judge, a Cook County seated judge, uphold an unlawful, break the law essentially. Did he uphold breaking the law? He determined that her appointments was no longer going to be a TRO, but a permanent injunction. Her appointments are invalid.
That is against the statute. The statute gives...
Which one? Name it. And please present a viable legal argument with case law. Come on, ye who did not go to law school. Please inform all of us on how a judge broke the law by signing an injunction by saying, you being a representation of that executive branch will not override the legislative branch, who gets to veto you with the majority vote. You did not get the board's approval to appoint a damn person in these positions. That includes an attorney and Michael Smith's dumbass. So no, please explain to us the breakdown with a legal basis, and you better cite plenty of case law and show precedents. Illinois State Supreme Court rulings, I want it all, nigga. How in the hell did super stupid somehow manage to meet your dumb ass? And you get to sit here and say a judge broke a law. How? What law? What state statute? And I dare you tell that judge that. Please tell Judge Thaddeus Jones that he broke the law signing an injunction. I dare you to do it. I double, triple dog dare you to tell a judge, a sitting judge, or I don't care if he retired, tell him to his face he broke the law while you can't cite case law. I dare you to do it. And I hope your ass is summoned to have to appear before him and be forced to give a legal argument on it. I want you to tell me the state statute. I want you to cite case law. You better have some precedents. You better have a lot of shit to tell me how I broke a law. Please do it. Please let that happen, Lord. Because that would be epic. It would be another brutal smackdown. But no, go ahead. You're the only one that somehow believes in your alternate reality in your mind that is not here on earth with us, because both of y'all done lost your minds right along, super stupid. But please tell us the legal breakdown and give us a legal argument, the law, and how exactly he violated it by signing that injunction and by saying that her appointments are unlawful and will not be appealed. And this court will not sit back and allow her to override her legislative branch that has the authority and ability and the power to say, we voted that you will not make these appointments. We don't approve of them. Goodbye. Kick rocks. Please tell us how that judge broke the law when he signed that injunction. Come on. We're waiting, you dumb goon.
The mayor.
We'll wait.
Attorneys used to hang out with Shaw too back in the days. I'm sorry, go ahead.
Man, don't nobody give a damn about that. Shut your fat ass up. Nobody cares. Because I'm irritated at him saying a judge broke the law.
Now, I'm going to tell you why I never went against a mayor's appointment powers. Because at the end of the day, the person going to sit.
How does the mayor override the judicial branch of government? How the hell does that happen again? Did he say exactly how? The judge did something illegal or unlawful? Did he say that? Did I miss it?
The mayor is allowed to appoint every 30 days. Now, I'm going to tell you why I never...
That's his legal argument?
...a mayor's appointment powers. Because at the end of the day...
Uphold an unlawful, break the law, essentially. Did he uphold breaking the law? He determined that her appointments was no longer going to be a TRO, but a permanent injunction. Her appointments are invalid.
That is against the statute.
Which one?
Gives the mayor
that attorney used to hang out with Shaw too back in the days. I'm sorry, go ahead.
When the board
I don't care. No one cares.
Agree to an appointment, the mayor is allowed to appoint every 30 days.
How does that present your dumbass logical legal argument again as to how the judge violated the law? Which statute was it? He didn't even say the statute code. Give us the ILCS code. And give a legal argument on how the judge broke the law signing that injunction when the board of trustees that represent that legislative branch have the power to veto her with a majority vote to decide whether they want to approve that appointment or not. This is not a dictatorship, you clown. So tell me, how exactly did the judge break the law or violate a statute code? Name the code, give the legal argument, cite case law, Illinois State Supreme Court rulings, show precedence. Come on, you want to play attorney, go ahead. Because he ain't said shit about how exactly the judge broke the law. I hope Judge Thaddeus Jones watches this video. Please, dear God, let that happen. And summon this idiot to court to have to explain his nonsense and buffoonery. Please let that happen. I'm here for it.
Now, I'm going to tell you why I never went against a mayor's appointment.
Because you're a simp. You're a simp.
At the end of the day, the person going to sit.
No, they're not. They can get voted out.
At the end of the day.
Or recalled.
I had issues with people when...
They don't have absolute power. That's not how it works.
They brought to the table. But you know what? I said, hey, they the mayor. I got to respect that. That's who they
So the hell what?
When you get to be the person... This is my issue with it. When I felt I wanted
he still ain't explained how the judge violated the law.
I ran. And when I didn't win, as mayor, guess what? I went on about my business. I didn't continue to stay and
how did the judge break the law? Break the state statute?
Because I understood one thing. What, Mike? People at Dixmoor wasn't ready for me. They didn't want me. They wanted somebody else. And I moved on.
I'm going to tell y'all this right now. No judge would permit him to say half of that BS in court. None. They're going to ask him, explain to me with a legal argument. How did I break the law signing an injunction? What state statute did I violate? I wish to God that would happen. You guys have, when I tell y'all certain things, it's for a reason. You know how epic it would be for him to be summoned to court, to have to explain to Judge Thaddeus Jones how he violated state statute signing an injunction. And he can't even cite the state statute or give a legal premise or basis as to exactly how a sitting judge violated state statute signing an injunction to keep a dumbass mayor from trying to believe that she has just irrefutable absolute power when she only represents 1/3 of government. You don't override your legislative or your judicial branch. Please let this man be summoned to court to have to tell that judge to his face how he broke the law. That's a very serious accusation. You better have some case law. I don't even hear a chief complaining this. I don't hear an actual claim being made here on the finding of fact or law at all. He won't even cite the ILCS code that was allegedly violated. This is what happens when you get two useful idiots that do nothing but run their mouth and talk about how somebody is beneath them. God help us all if anyone is beneath Wendy's cheeseburger up there at the top. Help us all, Lord.
You got to understand that. And once you understand
tell that judge that. I dare you.
I may not agree with the mayor, but I gotta respect the chair. That's the chair.
But he won't respect the court.
One day you
not
might
the
be
court.
sitting in that seat.
Won't respect
Do
the
you want
judge.
people coming up there doing that to you? No. And I'm not saying I was always right as a trustee. There were some things I did to my predecessors as mayors that, as I look back now, I say, Mike, man, you should have done that a different way. You should have done it a different way.
What the hell are you talking about? Mayors don't have absolute power. What are you talking about? They're elected. They can be recalled. They can be voted out. They can be removed. They can be put under FBI investigation. They can be criminally indicted. They can go to prison. What the hell are you talking about? How exactly did the judge violate a state statute signing the injunction? That's all we want to know at this point. So does Judge Thaddeus Jones. We all want to know how that happened. Inquiring minds, we're all inquisitive to know your legal argument on this, since you want to play attorney all over social media. Because this clip can be played as evidence in court. So we all want to know exactly your legal theory on that. I'm still waiting on him to cite the code and case law. Cite one case law. Do you even know how to cite case law? You know what? This is good grief.
And that's growth. That's maturity.
He's saying nothing that a judge will be interested in.
I said
nothing.
You gotta respect the seat of the mayor.
He'll tell the judge that. He's gonna laugh at you, clown.
Or not, the Bible says it. We ought to respect those that are in leadership and in authority.
Yeah, why he disrespects a whole judge. While you disrespect a whole judge and the injunction order that judge signed, which is effectively considered part of law. These orders and rulings, they are to be upheld as if any other law exists. That's how they're effectuated. So you have not explained how that judge violated the law. Why you want to sit here and try to give a mayor, a simpleton, absolute power as if she overrides the other two branches of government? You are about as stuck on stupid as it gets. Good grief.
We may not agree, but guess
it's
what?
not a matter of agreement when it comes to facts and law.
To go at your pastor and tell him, hey man,
you ain't got to like it. You just uphold it and adhere to it.
Pray for him. And you ask God to touch his heart for him to do the right thing. You ain't got no business going up and disagreeing with your leader.
Yes, you do. You have the right to do that.
Fact is saying that if that's
the First Amendment right.
Did you feel that you did that in Dixmoor to people who had?
I just talked about that.
Just said it.
I just said it.
He's a hypocrite. Y'all narcissists. I told y'all narcissists don't understand hypocrisy. They don't care about that. She does not have absolute power, and what you're saying is very dangerous. It infringes upon the First Amendment right that we all have to actually air our grievance against an elected official. What are you talking about? You don't have the right to do. Yes, we do. See, this is the dumb shit that gets played in court to help understand the premise as to why a judge gave a brutal smackdown to Super Stupid and reminded her and Max Solomon, you all don't get to tell Dalton Park District or the Board of Trustees or any citizen that they don't have the right to be heard. A judge said that because that is a part of our constitutional right in the United States of America. When she goes and gets shipped off to North Korea, because obviously these three buffoons enjoy a dictatorship. Why be in a democratic nation? I don't understand. You don't care about a democracy flowing. Go wherever they have a dictatorship and enjoy it. I'm sure North Korea and Russia would be very fun for the three of them. Keith McBurger, Michael Smith, and Super Stupid. Take y'all asses where they do uphold a dictatorship or a monarchy even, and get the hell out of here. Because he is literally saying you don't have the right to air your grievance and express yourself and to freely speak. Yes, you do. The Bible says also, thou art to obey the laws of the land. There's another Bible scripture, fake Christian. And you sitting here saying a judge violated a state statute and can't say how, or the code, or case law, and you want to sit here and talk about respecting a leader, but yet you disrespect a whole judge. You're a goon and a simp with no spine. Bro, and you don't go somewhere, go grow a sack, Michael Smith. Grow a sack.
I was actually trying to read all this shit at one time. Chill out. That's why we go. That's why y'all.
He didn't say that. He contradicted himself by saying that a judge violated a state statute.
So
get out of here.
Back up. I did, and I'm gonna tell you what I did. When I recognized it as I got older, when I seen my two predecessor mayors, Kevin Grimmett and Dorothy Armstrong, I had to go to them and apologize. I said, man, I apologize. I was wrong.
I hope he planned on apologizing to that whole judge. He said violated a state statute.
Okay, so you should understand the people that are doing what you gotta make right yourself.
I do understand it, but what I'm trying
he
to
doesn't care.
If I can help a person
why he
not
won't
make the same
apologize
mistakes
for
I
calling
made.
these women female dogs.
Who? Me?
Shut up.
What are you talking about? Dave's Double McJuicy? What are you talking about? What does that have to do with anything Michael Smith just said? First of all, Michael Smith is a hypocrite. Because I want to see you go to Judge Thaddeus Jones' courtroom and apologize to him for disrespecting him by saying he violated a state statute when you're not a board licensed and certified attorney and can't give legal argument to express that stupid ass opinion of yours. Just feckless in every way. At the end of the day, this is pretty much the end of this video for this portion. So we're going to get to that election board hearing where these two get utterly destroyed, and I am here for it. Okay, y'all. So here's the video from Critical Smoker's channel. You guys make sure you check out the full election board hearing from start to finish. As I've always said, things concerning law and politics sometimes can be very, very boring. This is an election board hearing based on Goon 1 and Goon number 2, biggest size me, objection to Napoleon Harris and a couple of others, being nominated. And the problem is that, one, they're not attorneys. Michael Smith and Keith McNugget are not attorneys. So their objections that they provide will not be expressed in a legal term or a legal manner that would even make sense to the most on the most basic fundamental level. One, and two, they provide some documentation of the objection that was not properly filed. And as opposed to them coming with the original file stamped copy or stamped objection document itself, they brought in a photocopy of it because the stamp was not colorized as it typically would be if it's an original stamped document from the clerk. And that stamp is usually red. He brought in a photocopy that was not even all of the pages. It was 2 pages. And the stamp itself was black, which indicates that it was photocopied. You won't get a photocopy of an objection or any document, especially if it can be used in a court of law. It has to be the original stamp on it from the clerk. So either he couldn't afford to get the original stamp copy or he never had it to begin with and tried to pass that off as an exhibit. The reason why this hearing, just to give a little backdrop on this, because I'm not going to play the whole thing. The reason why this hearing is occurring because of the objection in and of itself, but what these two goons decided to do was to withdraw the objection because they knew they didn't have any valid exhibits or evidence. They didn't even have a valid objection as far as a claim as to why they wanted to object. They lied and said that Napoleon Harris did not meet the residential requirements when that's something that can be easily proven by his attorney. These two are not that smart. They don't know the law. They're not attorneys. So for them to just go out and say these dumb, frivolous things, just like Max Solomon filing these frivolous lawsuits, in and of itself, it's the epitome of buffoonery and a clown show. But they get to the point, I guess, where they realize we need to withdraw the objection because he does indeed meet the residency requirement by law to be a nominee for supervisor of Thornton Township. All they're doing is throwing in distractions and trying to prolong or find ways to keep super stupid in power when she's under FBI investigation and it just doesn't damn matter. That's all they're doing. They're being useful idiots. And this hearing here is going to prove why I say they're useless idiots. Because they aren't even smart enough to hold their own weight, no pun intended, to even bring forth a viable objection and exhibits or evidence to challenge Napoleon Harris's residency. All the attorney had to do, representing Napoleon Harris, was prove that he lived within the district or within a zone that falls under Thornton Township to make him eligible to be nominated as supervisor. And this is not inside of a court of law. This hearing's like inside the town hall, whatnot. But if it had to go to a court of law, all of the testimony, the exhibits, the statements made here, everything should be recorded, minutes, something, can be used against them in a court of law. So them putting on this dog and pony show is stupid. What a vile waste of time and tax dollars for the dumb stuff they're doing. This is the same Michael Smith that I just showed in a video earlier that claims to know government that no one else knows and the law when he could not even produce proper exhibits. An original file stamped objection. And it has to be filed within a certain time frame because there is such a thing as a timely filing limit. Yes, there is. And because he's not smart enough to know that, he tried to do something at the last minute. It ended up being a photocopy. It was 2 pages. And then it didn't have the original seal or stamp on it that is supposed to be color. It's supposed to be in red and signed by the clerk. And he had a photocopy. It was buffoonery. So you're going to witness him throw an epic man baby tantrum, talk about a bunch of nonsense after he opted to testify because he thought he was doing something and he wasn't. So here's the part where the clerk has testified. She submitted what was given to him, and then he decides to jump his happy ass up and to try to testify and still get destroyed by the attorney, all for I guess our entertainment purposes, because it's definitely not for anything of a legal merit here. I mean, if the judge had to watch this, he would just laugh. The judge would have a field day with this crap.
I think that the best evidence that the board has is before the board right now. But if the board wants to see that, if the clerk has it handy, we can certainly have the clerk look at that. But this is fine.
I'd like to make a suggestion. When these pages of documents were admitted there are photocopied, if they've not been taken apart, they just be folded over so that the staples mark just...
Yeah, they're photocopied.
Okay.
That's what he just said. These are photocopied. If they were the originals, they would not be printed on 2-sided paper. They wouldn't be folded over. None of that. When anyone who just has an understanding of how to, submit exhibits to the court on a basic level, you wouldn't fold those exhibits up. Don't tamper with it. It has to be the original document. If it's a, documented, written type of exhibit, it needs to be the original. You have something you got from the clerk that has a stamp notary or has been filed or anything. It needs to be the original. You keep a copy, But submit the original, or just get two originals. Get two objections filed and stamped with the original stamp on it. The original seal, notarized. Have the originals. You give them one, you keep one. Pay the money for it. You gonna go cheap now? Y'all trying to sit here and defend super stupid with all your might, and you gonna be cheap when it comes to getting a file stamped document? Are you kidding? It's a joke. Photocopies are not acceptable. Nope. Not at all. They're not even bothering with it. So that's what he was saying. No. It's photocopied, and it's not gonna have any of that if it's the original. It won't.
And so, if I may, the copy that I received through my FOIA was exactly done that way, because you can see that the page was just folded over.
Yeah.
So does the majority of the board want the clerk to go get additional receipts? No? Okay, so I'm voted. Yeah, you're outvoted.
You know what, as far as this evidentiary hearing, this was a notarized,
Photocopies are not notarized.
do,
No, sir.
in fact, have a notary.
What?
That can come and testify
Nope.
of it being 3 pages
Nope.
of her notarizing.
Why would you not bring that with you? Why didn't you have those 3 original pages of an original file stamped in color, notarized document? Why do you not have that? You filed it. You wrote it out. You filled out the objection. Why do you not have that, you dumb goon? Useless idiots. Useless idiots.
And I would like, if so, that be put as well into.
You should have that.
I would say that is not relevant in my.
It's not relevant at all.
It was filed with the clerk's office.
Right.
That's what matters.
Right. Irrelevant. The notaries don't need to come in and testify to that. No.
There could have been a page missing somehow, a page could have gotten
Right.
lost.
Exactly.
What is relevant is what was filed at the clerk's office.
Right.
And
That's
the only
it.
thing that best jurisdiction with this board is what is filed at the clerk's office.
Office, not who notarized something. He could have notarized
The
it.
board has enough evidence to make a decision as to whether the objection contained 2 pages or contained 3 pages, and to make a ruling as to the scope of what is being objected to.
Did we see what the objection is by phone?
Oh, I'm sorry, yes, does the objector want to?
Dentist.
Anything?
2 pages that we give you, there were 2 pages.
Oh.
So
And
basically,
can I ask another question? When your original is.
Where's the original?
Pages, was the first 2 pages back to back and then the third?
No, he never had it. Where's the original?
Yeah.
what's
Print that's on the front, so 3 single pages.
Yours is back to back.
Ours were
No,
not back
I
to
never
back.
do back. I never do
Back to back. No.
we did that at our office for the purpose of not killing so many trees. When we make documents, when we make board packets, well, no, it's not, it has nothing. When we make our packets for the board, that's just us copying it in a manner that is going to.
Right, before what's supposed to be considered a legal objection, it should not be printed on front and back. It should be single page, single side. The font has to be clearly, legible and readable to the average viewer. So if they get a FOIA request, you can read and understand it. But why does he not have what he filled out as the original? Why does he not have that? Before he left that clerk's office, don't you think if you came in with 3 pages, you would walk out and make sure you have 3 pages? Why the hell would you walk away with 2 pages that are stapled together and photocopied? Useless idiots. Useless idiots.
I was asking because if it was back to back, sometimes they missed that back page.
They actually will. And, just so the record is clear, to request to call as a witness, we normally remove that
Do we have a second on that motion? Okay, all in favor?
Aye. Nay.
Okay, motion carries 2-0. The notary will not be brought in for
There you go.
testifying as it relates to.
Because they're not needed. I'm not gonna bring no notaries in to testify on what they notarize when they don't care about that. They care about what's filed with the
I
clerk.
think that the board has enough information before it to make a ruling as to what the objection entailed. Not a ruling as to the validity of the objection or anything else, but just what was contained in the objector's petition, whether it was 2 pages or 3 pages.
So I don't think I can't testify. Keith Price can't testify.
Why? Why would you want to?
Turned in, we are part of this evidentiary hearing.
No, you're objectors.
We should be able to give our testimony.
On what?
We in fact filed before this electoral board.
It doesn't matter what you say you filed. It's what you can prove that you filed. Your exhibit, your evidence is only 2 pages. You want to testify on how you still thought it was 3 and then you brought 2 pages? Why didn't you keep the original document? Why didn't you walk out that clerk's office and count the number of pages you had in your hand? And you should have questioned if it was stapled or not. You should have questioned, what the hell is this? Those documents don't get stapled. You don't staple that stuff. Why in the hell would you walk away with 2 pages and not count the number of pages you know you filed? If you filed it. No matter what was notarized. That would have been, first of all, the notary would not be photocopied and acceptable. You cannot accept a photocopy of a document where the notary is also already done on it, and you basically photocopying the stamp from the clerk and the notary from the notarist. That document would not be acceptable either way. All it proves is that you didn't have a proper objection filed. That's all that proves. You weren't smart enough to look up how to file a proper objection, or write one, or read one, or make sure that the stamp was colored or notary was done on 3 pages, on 3 pieces of paper.
I do have a hard stop at 5:10. It's supposed to be smart 5:15.
Who these useless idiots? She was like, "Yeah, I got a hard stop at 5:10."
And we haven't even gotten to the other case.
Yeah, which is still stupid. It's another stupid case. From one dumb case to another. She was like, I got a hard stop at 5:10. Ugh.
2 pages, and they are.
Y'all see the look on her face? It was epic.
The evidence that you have 2 pages as a receipt.
That's what's on this particular receipt.
That you were handed at the window.
Yep.
Useless idiots. You didn't count the pages? Why?
Nobody games. You got.
So what you want to testify to? You didn't check how many pieces of paper you had in your hand? What? You don't need to testify to that. That's apparent. That is obvious. We can all pretty much deduce that you didn't check it. We all can kind of gather that as a consensus that you weren't smart enough to count 3 pieces of paper and check it and make sure that the original stamp from the clerk in red was on the document, and then go get it notarized and have at least 2 sets of those original stamped documents. So in total, you should have 6 pieces of paper. In case you didn't, that math went over your head, 3 times 2 is 6. You should have had 2 sets of a 3-page document with original stamps and a notary on it. That's not stapled. And you 2 useless idiots didn't even check for that. What goons you are. Oh, this is, boy, you can't get, this is priceless. Whoo, they so precious. Oh, bless their heart.
It doesn't take a minute.
Man, How they gonna fall apart on a deposition? Yeah, boy, I hope they get summoned. Please, Lord. Yeah, she's not trying to deal with this dumb shit. She was like, "Oh my God, I'm ready to go." I think it's enough.
Take a look at this.
Okay, can we exclude?
Excuse the clerk. All right, you good to go, ma'am. Thank you.
Your deputy clerk, or leave them with us, and we'll give it to the deputy clerk just in case there's any additional questions on those.
She's all right. Bye. Y'all have a good one. Enjoy this buffoonery and clown show.
Okay.
Deuces.
Of the objectors, is it Mr. Smith, are you going to testify? Okay.
Boy, them hands are too tight and too little for you.
Yes. Just for the record, the candidate has an objection to this testimony, as the best evidence is actually what's in the record. And the admission by the objectors is they received a receipt, which is a scanned copy of the 2-page objection.
A scam copy. I love it. Oh, y'all, I think he said scanned. But for the purposes of the captions here, yeah, a scam copy. I love it.
Michaela Smith, SMITH.
Useless idiot, number one.
And did you file objections to the nomination papers of Napoleon Harris?
Yes.
Because he's an idiot.
That was on December 23rd, 2024, at approximately 3:45 p.m.
Yes.
Okay, and I understand that.
But can't tell you why, though.
Related to the objections? Testify.
When we came down to file the objections, of course it was
Based on some dumb shit, because he doxed a state senator on national television. Only for his attorney, Napoleon Harris Attorney, to prove this man does reside within the residence within the acceptable zone or district to be nominated for the supervisor of Thornton Township.
Make sure that you don't have pages mixed up.
Objection, hearsay.
Hearsay.
Hold on, there's an objection pending.
Because he's not smart, he doesn't understand how objections work.
Okay, we've got a motion and a second to sustain the objection. All in favor? Okay, the objection is sustained. That means that you cannot testify to what
What's someone else told you and all this other nonsense. Nope.
Otherwise, that's hearsay.
So,
You would think, oh no, wait, he didn't know that already? This buffoon that knows so much about government and law, he didn't know what a hearsay objection is? Someone had to tell him that? If he knew that, he would have stopped talking the moment the attorney said objection. Because you have to wait to either, if you're in a court of law, the judge gives a ruling on the objection, or in this type of hearing like this, they have to vote on that objection. They have to give a majority vote on the objection to whether they're going to sustain it or overrule it. And I can guarantee you he doesn't know how that works either. He's just an idiot.
I'm checking to make sure that we have.
Oh, Lord.
Napoleon
I'm going to call them idiots all day. I have no sympathy for that. None. They choose to be useless idiots.
As well as the 2 pages.
They could say, no, this ain't worth it.
And that is
Super stupid, kick rocks.
Does the board have any questions?
That is my testimony.
Did you receive a stamped copy from the clerk?
I did receive a stamp copy.
You have that document that you received?
Yes, I did.
Where is it?
Yes, I can.
Where is it?
Yes.
Sure. I'll mark that as Exhibit R.
And he folded it up like a tripod. Why did you fold that exhibit up, idiot?
File.
Yeah, why he got a beer belly and everything else? Why did you fold that up? You're not a smart person at all. And if you knew a little bit about the law, you know not to fold up exhibits you're going to use in a hearing for anything on this caliber or in court, especially in court. And let me tell you something. If this were a court hearing, he would have had to file that exhibit to the court and submit it also to the opposing party as discovery within a certain time frame, or else it would not be admissible. It would have to be that exhibit would have to be so damn credible where the judge says there's no way we can proceed without introducing this and admitting this into the court. But what he submitted was folded up. It had at least 3 folds in it. And it's 2 pages. It's not the file. They all agreed that that is a photocopy. That's not the file stamped document, because it's not the original. I don't even understand why you even walk away with that. The clerk should have been told, listen, you're going to give me an original. I'll pay for it. As a matter of fact, I need 2 originals. I need all of them stamped. And it needs to be printed on, it don't need to be printed on 2 sides or any of that. It cannot be stapled. And I need it printed on some thicker paper. That good paper. That you have to, you spend a little bit more money for, because you know that this document is that valuable. He didn't even do that. He didn't even count the number of pages he was given when he walked away. Didn't see that it was, he didn't even care or know that it should not be stapled. Useless idiots. Useless idiots. What are you testifying to? You had already said that. You didn't need to be
We have a motion to accept
sworn in and give that same statement.
Exhibit R.
I move we accept it as Exhibit R.
Second.
All in favor?
Aye.
Motion carries.
Just for the,
Of course they're going to accept it. They're like, yep, this is proof that he's not that smart.
title on the page that's stamped.
Objections to nomination petition.
Please read the first line of the second page.
Offers depending on the procedure that the multi-township central committee has selected.
Thank you.
Okay, anything further from the board?
And he keep folding it up. You keep folding it up. You useless idiot.
Okay, thank you. Mr. Smith, you are excused.
Okay.
Oh, I'm sorry.
Yeah, just two, 3 questions, real fast. You said you wanted to.
Y'all repeating yourselves.
Okay.
Mr. Smith, upon arriving down to the clerk's office, was anyone there?
What?
No, it was just myself and you.
Was the office totally locked down?
Yes, it was.
How long did we wait for the clerk to get there?
We waited at least about maybe 4 to 5 minutes.
Oh no. Oh no.
In that time?
The amount of time that Keith McNugget wait in line for a Big Mac and a Happy Meal. Oh no, 5 minutes. Oh no. Oh dear Lord, what are we gonna do? Waiting 5 minutes for the clerk to arrive. On December the 23rd, get this, on December the 23rd, 2 days before Christmas. Oh, what a tragedy. You had to wait 5 minutes for the clerk to show up to accept your stupid 2 or 3 page document on an objection that you ultimately withdrew because it had no legal premise or basis to it, no finding of fact or law in it. It was absolutely false, and all because you're a simp for super stupid who has somehow taken over your nutsack and your spine. December the 23rd, bro, ain't nobody coming to work. Who the hell you expect to be there at 3:45 on December the 23rd? That is the most grinchiest, most Scroogest thing to do. Is to have somebody come to the office on December the 23rd at 3:45 p.m. to take a invalid, improper objection. Kick rocks, you useless idiot. You kidding me? I'd be mad as hell. Did you wait 20 minutes?
Okay, all in favor?
They'll wait that length of time in the grocery store to buy a turkey. For Keith, it'll be 2.
During that time, did I ask you to make sure that we didn't make any mistakes? Napoleon had 3 pages, and Mr. Baker had 2, and to make sure that the last page,
Watch what turmeric does to you.
2, and to make sure that the last page of Napoleon was Napoleon's name, And the last page of Mr. Baker's was Mr. Baker's.
Objection,
Yes,
comment,
we
question.
did. Yes, I did.
Nope, you don't get to answer after he made an objection. Because you're not that smart and you're not an attorney.
I mean, I agree that it is a
Agree that it's a
compound
compound
question.
question, but I think we can hear it, so
Overrule?
we'll get to the same place that that's where we'll
Second.
handle the objection.
Okay, all in favor of overruling the objection?
Aye.
Okay, we can continue on.
Yes, I checked and made sure that Napoleon's 3 pages were intact and George Baker's 2 pages were intact. And that the back pages match the title of whoever we were objecting.
The back pages?
That was Napoleon Harris.
Didn't he say it was not printed on the back page of a paper?
Any other questions, Mr. Price?
What back page?
I have no further questions.
Okay.
Did he just contradict himself?
Mr. Smith, with regard to the receipt that you submitted at the request of Judge Swanson, that's Exhibit R, correct? It's in front of you, right?
Yes,
And earlier today, right before we started this hearing, you represented to this board that you had a receipt that had 3 pages, correct?
I do not recall that.
You don't
recall that this happened 30 minutes ago?
Telling this board
45 minutes ago.
you have the receipt of the objection, which was 3 pages.
I do not recall.
I object.
What do you mean?
to the line of questioning with the number of pages.
What are you talking about? That's what this whole thing is about. The number of pages.
Objection overruled, cross-examination. We need a second? I'll second. All in favor to overrule the objection?
Aye.
Motion carried.
And Mr. Smith.
Yeah, they overruled Keith McChicken Nuggets' objection because it was dumb. Most of this has been about how many pages was submitted to the clerk. Because that's what they're saying did not match what they turned in. They didn't get back 3 pages, they got back 2. So how is it that the number of pages is somehow now deemed irrelevant? When this whole thing was mostly about them complaining to the board to say the clerk did not give me back 3 pages that I submitted from Napoleon Harris. So now all of a sudden the number of pages is irrelevant. So why are we here? Why are we here, Biggie Size Me and McFrosty? Why are we here? Are you kidding? This whole thing is about that.
The official receipt that you received from.
Now he don't recall something he said 45 minutes ago.
Miss Wells, which is actually a physical.
Michael Smith, you useful moron. Useless moron. All you got to do is rewind this video and then you can go back and read the caption, or you can hear yourself answer that same question from 45 minutes ago. But to say you don't recall when it's being recorded is the dumbest thing to say, because the video can easily be replayed over and over and over again. So saying I don't recall is dumb. If anything else, why not just say, may I ask the clerk to recall what's on the record or in the minutes or whatnot? Because I think I said yes, maybe no, but I want to be accurate. But to say I don't recall what I said 45 minutes ago when you were being recorded in a video is absolutely stupid. You're not a very smart person, are you? What's 2 plus 2?
Of the actual objection that you filed on December 23, 2024.
Holy Jesus.
Can you please restate your question?
No. You understood what I asked.
What you brought today to this hearing is the official receipt that you received from the clerk's office.
On December 23rd.
It's actually a physical receipt of the actual objection that you filed on December 23rd.
Yeah, he don't understand all that verbiage. Because
I can say that this is the copy of the receipt, but this is not the copy of the objection that I filed.
where is your original? You found it.
On that document.
Black.
The
Black.
color is black.
So
It should be
she made
red.
a copy and gave it to you, correct?
Yes. Because he's been saying that the whole time.
Say what now?
Did she make a copy?
Oh,
of
now
the
he's
objection?
stupid.
Or did she
He's really
give
being
you
stupid.
a physical copy with the red stamp on it?
Red stamp. Y'all hear that?
Black stamp that I received.
Did you know
Stamp that I received.
Yeah, it's black because it's photocopied. It should be red.
Ms. Wells, you presented an original and 2 copies, correct?
Correct.
You did not have an additional copy for her to stamp, correct?
I did have an additional copy. We did have additional.
So you have 4 copies?
4 copies, and we kept the copy for ourselves.
What?
But you
Where are
didn't bring
those?
to this hearing a copy of
The
receipt
original.
that she gave you that bears the red
Red stamp.
seal stamp.
Thank
Of
you.
the clerk with the date, correct?
No, he didn't.
I don't have a copy because I have a black copy.
Where's the red one? Where is the red stamped copy at? Where at? Where's that at? Where is that at, you useless idiot? Where is it? That is what they should be asking flat out. Where is the red stamp copy at? Because it's not at the clerk's office. And if you are the one that filled out the documents, then why don't you have one? Why don't you have one? What is going on? Why would you not pay the extra $5 to get the red stamp copy of it? Because most of the stamp copies are red. It's red for a reason. So when you go out and think that a photocopy is going to be legitimate, you're dead wrong. It should not be black. It should be red. And it should not be stapled or folded. They can't even preserve exhibits properly. Good grief.
Did she make a copy of what you filed at a copy machine and give it to you?
Yes. Yes.
I have a black copy stamped.
It's a yes or no, useless idiot.
Objection from the clerk's office.
Yes or no?
Did you see her stamp that document with a black ink stamp?
I have a black copy of the objection.
So now he's going to play stupid with words because he doesn't understand the
While
definitions
you were standing there,
or concepts
the objections that you handed into her
or how to spell them.
was Mr. Baker's and the objection to my client, Napolean Harris, correct? Those are the 2 objections that you were filing at that time, right?
I did not hand in any copies. Mr. Price handed the copies to Clerk Will.
And you were right there.
I was right there.
Right. And it's just
So you're attesting what
and
was
Mr.
given.
Price and someone else, correct?
It's just me and Mr. Price first for the first 5 minutes.
Who cares? No one cares about that.
Was away. And then came the clerk.
It doesn't matter.
Being away for those 5 minutes did not prevent you from filing your objection timely, correct?
No.
We filed our objection at
3:45.
before 5 p.m.
So what's
With
5
regard
minutes?
to this document, are there any other receipts that
Do y'all understand why this attorney is brilliantly destroying him with simple questions that really only require a yes or no answer? He's doing this for a reason. He's basically saying, you want to sit here and talk about how the clerk made you all wait 5 minutes as if you wouldn't wait in line at McDonald's for a bigger size fry for that. Or, nor did it prevent you from filing the documents by 5 p.m. The attorneys ask these questions with some of that legalese in there for a reason, because he knows they're not attorneys. They're not even going to understand a reasonable objection. So, when you have 2 useless idiots sitting there sucking up air on God's green earth, they don't understand half of what's going on. They don't understand the strategy behind the attorney asking these very simple questions that require a yes or no answer. To say, I don't recall, is the dumbest answer ever when you have a recorded video and you have someone in there recording the hearing. So it does not behoove you to say you don't recall when you can just ask the clerk to recall it. I'm sorry, what did I say 45 minutes ago? Okay, so that's what I said. Because I just want to make sure there's some consistency in my testimony that this idiot chose to give. He was the one who was like, I can't testify, because he thought he would be able to just slam dunk it. He forgot that there's what's basically known as a cross exam or rebuttal, where the opposing counsel gets to ask your dumbass all these questions that I knew he wouldn't be able to answer, just on a simple level. My kids would be able to answer these with ease. Yes or no? It is irrelevant that the clerk was not there when y'all got there at 3:45 on December the 23rd, 2 days before Christmas. Let that woman go home and be with her family. You plump Scrooge. And chicken and waffles sitting next to you. Let that woman go home and be with her family for Christmas. Why the hell are y'all up there at 3:45 p.m.? And then tried to make it seem as if, we could not get it filed timely because she made us wait 5 minutes. What kind of shit is that? I'm impressed at the fact that she was able to get to that office in 5 minutes. That's not a relevant testimony. That's not that's not relevant to this at all. It didn't stop you from still filing it by 5 p.m. You're the one that said it was stamped at 3:45. So what the hell is... Who cares if she made you wait 5 minutes? It's the point that the attorney is trying to make. It didn't stop you from filing it timely, did it? No, it did not, because it was still done by 5 p.m. So the answer is no, useless idiot.
Have from the clerk that contains a stamp on it for this objection.
I have a copy of a black.
He keeps giving all this word salad as a response. Yes or no?
December 23rd at 3:45 p.m.
Move to strike as non-responsive.
Exactly, non-responsive. Yes or no?
I would agree with that motion to strike.
Yeah, strike that off the record because it's stupid. Oh my God.
All in favor?
Y'all know you can give an objection as non-responsive. That is a type of objection that can be given. So if the attorney asks a question and you don't answer the question, you keep going around in the circle and sugarcoating and beating around the bush. These questions are clearly simple to the point where anyone would know that they only require a yes or no answer. He's not even answering the questions being asked. So the objection of non-responsive, meaning he's not answering my direct question I'm asking him. So what he's saying, I want it struck from the record because he's a goon and a moron that doesn't have a spine. And he's saying all this nonsense that have nothing to do with my question at hand. They created this nonsense. They created this problem. He wanted to testify. He could have sat there and shut the fuck up like the normal person would have done. But no, too much like right. Too much like right. Too much like right.
Objection sustained. Mr.
Answer the question he's asking.
Please answer the question. The question was, do you have anything else? Do you have any other documents?
From the
Yes or no?
I have another stamped copy for George.
Specific to this.
He said any stamp.
No, specific to Napoleon Harris. He don't care about the other Baker
I
guy.
have a stamped copy of George Baker's objection.
No, he said Napoleon Harris.
I'm talking about the objection of Mr. Harris. This is the only receipt that you have from the clerk related to
And
the
I
objection.
answered your question.
No, you didn't.
Well,
They just did an objection on non-responsive,
Yes, this is the copy.
and it was sustained.
There are no other copies, correct? Yes or no, sir?
Yes or no?
This is the copy. Yes.
What?
Okay, so that's one, correct?
So he doesn't understand the definition of the term additional? Is that what I gathered? Yep. Michael Smith does not know the definition of the term other or additional because clearly he's trying to avoid answering that question. Are there any other copies of an objection against Napoleon Harris? Yes or no, other than what you have here that was already admitted as an exhibit. And I think it was admitted as exhibit R1. So It's already been admitted. Are there any other copies that's out there on earth that is an objection you filed against Napoleon Harris? Yes or no? No, there are no other copies. This is the only one. But because he doesn't know the definition of the term other or any or additional or addition, math, law, government, cheeseburger, he's sitting here doing this word salad.
Sir, I'm not talking about George Baker.
I don't care about George Baker.
Objections to Napoleon Harris.
Exactly.
Okay.
There's only one receipt that you received on
there's one.
December.
I keep saying it. I keep saying the same damn thing. There's only one. Damn.
Stop using profanity, you idiot. What a dumb goon you are. You chose to testify. Look at that attorney laughing at this. Is such so stupid. That laugh on that man's face.
Were any of those copies stamped by the clerk?
No.
Sometimes
So you only have one copy of a stamped objection.
So he said I got across the school.
What is wrong with you?
So there's no way, we're not going to see a 3-pager with a stamp, right? It doesn't exist, right?
Right.
It doesn't exist.
According to everything in the report.
All because he couldn't say yes or no because he doesn't understand the definition of the term additional or other or any.
Copy be made in the same way that the directions is to the others folded over and not taken apart.
Right, you can't fold it over.
I got it. He said I had a question. I just got across to clarify a couple things that
Okay, just a couple more questions.
This is a shit show. This is a just pure shit show.
It's been going on for 45 minutes now.
Simple issue.
Go ahead.
Simple.
we all just
Because they're simpletons. That's why. Simple issue going on 45 minutes about 2 or 3 pages of a document that's still improperly filed because they folded it up, stapled it, photocopied it, and then they can't even stick to how many pages it was for one simple objection. He's dancing around the bush on whether or not there are any other additional copies because he doesn't understand the definitions of the term any, other, or additional. And then a 2-piece wing and a fry here is going to sit here and still beat that dead horse to the ground for reasons unknown. Because they're not attorneys, they're not that smart, and they should not be sitting here defending super stupid, putting on this clown shit show, and all for what? For you to still prove how dumb you are? Are you kidding me? You all see why I played that clip of that interview they did with Bishop earlier? Because this is proof that you can't take these 2 clowns seriously. And then they really were, they really had requested to withdraw the objection because it was invalid. It was not based on any fact or law. And your objection should be based on fact and law. And they weren't. So they were improperly done either way. Period.
Mrs. Smith, earlier today,
For sake.
3 documents with 3 red stamps. Is that correct?
Correct.
Where are they? Why wouldn't you all bring those documents to a hearing? Because they don't exist. They just don't exist.
Were those the 3 original objections that we must file in accordance to the election code?
The copies, right.
So the 3 copies that had the red stamp were the original filed documents. Is that what you're saying?
No.
Leading.
Because
No, it's not. Because they don't exist.
One, it had so many staples at the top of it.
The original would not have staples. It would not have staples. It's what the attorney that looks like Colonel Sanders at the head table keeps trying to say. The original file stamp documents will not have staples in it. It would not be folded over. Once you put staples in it and fold it over, by state statute, it makes that document inadmissible and improper. That is not considered acceptable documents, especially when they can be used in a court of law. So no, he keeps saying that. You can't staple them. What part of that are they missing? I don't know. Why does that keep going over their thunk heads? They don't have brains. They're not of this earth.
Staples that were at the top of it.
They weren't copies if they didn't have staples. They should have been the original.
The paperwork that was turned into the clerk that's required by the election code, you must turn in 3 copies. Those 3 copies had red stamps, right?
Correct.
Okay. So your copy, you would have never got a red stamp because it wasn't.
You would have gotten that. Yes, you would have.
Your copy has a black stamp because it's a copy, correct?
Correct.
You would have the originals. You would just have to pay for it.
Besides the fact we know that the page 2 wasn't there, does it look like anything was been done?
Oh, Lord, that's irrelevant. Nope.
Objection.
Objection. Not relevant. Not relevant.
Yes.
Because before
It's not relevant.
I move we sustain the objection. No. What's your objection, Mr. Ledger?
That's not relevant.
It's not relevant.
As far as someone manipulator, what's going on there.
That's not relevant at all. And the insinuation of that is ridiculous.
I move we sustain the objection on the grounds of relevance and on the grounds that it calls for an explanation.
Speculation.
The witness is not qualified to do.
Right. Thank you.
Okay, all in favor?
Do y'all understand that? He's not qualified to give that type of statement. He's not an evaluator or assessor of these types of documents. He for him to even insinuate or speculate that there may be some line of tampering, he's not qualified to even make that type of assessment. Because he's not that smart when they don't understand the definitions of terms such as any, other, or additional. They're not attorneys. They're not forensic auditors of these documents. He's not qualified to even make that statement out loud and insinuate any level of tampering. But because they're not attorneys and they're not very smart, this stuff is just going over their head. It's appalling and egregious. Useless idiots. All because Super Stupid needs to feel like the smartest person in the room. Here goes the 2 goons she keeps around her.
Is approved, so that objection is sustained.
Right.
Next question, Mr. Price.
So you can't answer that question. Keep moving.
Zaxby's.
Next question. Objection sustained. Kick rocks. Oh, okay, shut up.
So at this time, I think that the board has probably heard all the evidence that it needs to hear.
Yeah, and it's been beating the ground.
Is there anything else that the board would like to ask Mr. Smith?
No.
Okay, is the board ready to rule on the issue of what was in the objector's petition?
I would ask that Mr. Smith's copy be marked as Exhibit S and entered into the record.
No objection to that? No, we're
R, sorry.
R.
Yeah, it's already, it already is. Yeah, it's R.
It's already there. Yeah, as I said that earlier, it's already there as R. Yeah, please document how dumb they are.
Okay, so, and this is, I just have to say for the record.
This is a clown show.
Unorthodox. I have never had to have an evidentiary hearing on what exactly was filed, so.
Right.
But this is a.
And they're in no position to insinuate something was tampered with.
What exactly was filed was the 2 pages.
Good grief.
And then at that point, if the board determines that, in fact, there was 3 pages filed, then, we have to make sure Mr. Ladizinski gets a copy of that 3rd page and figure it out from there. the board in fact determines that there's only 2 pages filed.
Right. Because they're not very smart.
The universe of what the objection is, and that's what the parties can then litigate going forward. Mr. Ledezinski and Ms. Centeno can then file their motion to strike and dismiss on that. And
I would suggest that if we're talking about 2 versus 3, that the 2 be, with the first page being objections to nomination petitions, and then the second page would be what we have been recognizing as the last page, or the page that starts out with the words office, comma, depending, and so forth.
and if I could also point out, I do tend to agree with you. I mean, obviously, I'm not a decision maker, but I think that there's 2 things that the board needs to look at with this, and that is, you've got the originals of what was filed. The statute requires that objectors file an original plus 2.
Right, an original plus 2 copies.
But when you look at the original documents filed by the objectors, you see 3 different sets of documents.
Exactly.
The 3 sets of documents, one has like 4 or 5 different staple holes in it. One has
It's not proper. It's not proper documents.
Staple itself, and then some holes outside of it. And the other one.
They folded up.
And that's what staple is still residing. And that staple has not, in fact, been removed, at least as far as I can tell. And in fact, Mr. Smith testified the one staple that we put. And that seems to me to be the one that there was no staple removed at all. So because there is what looks to be a complete copy with no staple removed, or no evidence of a staple being removed, I think that the best evidence before the board is that the filing only consisted of
2 pages. Right, that's it. It's that simple. It's a simple issue. We're on 45 minutes. Because 2 clowns decided to put on a shit show.
We have heard testimony from 2 witnesses, from the clerk and from Mr. Smith, as to the copies that are filed. We have as Exhibit P1, 2, and 3. Copies bearing.
Yeah, can y'all speak up? Y'all got these microphones. Speak in them.
Record, which was the copy that Mr. Smith tendered to us, which has been marked for record. The initial line, title on page 1, and the first line on the second page, each of these is a 2-page document, are the same on all of those documents. So the motion is that we find, after observing this evidence and hearing the testimony, that what was filed with the clerk was a 2-page document as shown with the red file stamps as Exhibit P, P1, P2, and P3. That 2-page document was the original, is what was filed with the clerk, and that we are finding. That's my motion.
I second.
Yeah, we all agree. They filed 2 pages, not 3. And they weren't smart enough to take out a staple that should have never been there in the first place.
After motion and second, there's always an allowance for discussion.
I just want to say to the objector, it's a hard decision, because I learned the hard way what you're just learning, to really make sure the receipt says the number of pages, to look at what's handed back to you, or bring.
Yeah, simple things. He didn't even look at what he was given, because it was December the 23rd at 3:45 p.m. Shouldn't have been up there. Go home. It's almost Christmas. Go home, idiot.
Very hard decision, but all the concrete paper evidence.
It's not a hard decision, lady.
So I will vote for the motion, but I appreciate the testimony. I thought it was very credible.
It was not credible.
But we just don't have any.
They couldn't even answer a yes or no question. And they got objected more times than anything else. It was not credible.
Okay, so
They wanted to bring in the notarist. There's nothing credible about that. The notarist wasn't needed. And then they tried to insinuate that it was tampered with. And they don't even have the brain matter to even start that type of conversation. So, no, it was not credible. It was a shit show. And a judge in a courtroom would not have permitted the last, This was 2 hours of 53 minutes and 29 seconds. Yeah, after about 23 good minutes of this, the judge would have been like, all right, enough. I'm ready to give a ruling. This went on 2 hours, too damn long. This is a clown show.
Chair Raymond?
Yes.
And that lady was ready to go. I got a hard stop at 5:10. Getting the hell out of here.
Motion carries 3-0. So the objector's petition now is confirmed. According to this record, it consists of 2 pages. The first page being the first page of the objection, the second page being the signature page. The reason that we recalled this case in the first place was for the withdrawal of the residency objection. Is the board still intending on withdrawing the residency objection?
Yeah, because they don't have a finding of fact or law on that.
The objector. Is the objector, okay. So motion, you're making a request to withdraw the residency objection?
Yeah, because they don't have any facts or laws to support it.
I have an objection because we have not taken evidence in this case, and it would require a dismissal of prejudice
Yep.
of those allegations because we've already taken evidence. And I was going to be asking to convert my motion to dismiss that I'm going to be filing into a motion for summary judgment with this transfer.
Good
So
job.
I do not
Good
believe
job.
it's appropriate to allow them to withdraw these allegations based on where we're at.
Good job. Love it.
I would just say at this time, why don't we just have both parties file something in writing because.
She ready to go.
We're just gonna keep going.
She ready to damn go.
If I may, hold on a second. If I may, my suggestion would be to.
Whatever you got to say, put it in writing.
That was previously set, Mr. Ledezinski, file whatever motion you want to file, whether it's a motion to strike and dismiss, any motion for strike and dismiss plus summary judgment, or however you want to style your motion.
Yep.
If I just make it, in my opinion, the evidentiary portion was solely limited as it related to the filing of the objection itself. So I still do think a motion to dismiss would be appropriate because
Right.
it does relate to the manner of filing, but your point is taken and understood, so.
And also because they're not attorneys, they have no idea why the attorney for Napolean Harris is doing this. It ensures that they can't keep bringing that bullshit up again. No one wants to keep having hearings on their boneheaded, wild hair theories that aren't based on any finding of fact or law. They could not prove that Napolean Harris did not meet the residency requirements because he did. It was that simple. And I said that in my video when I reacted. And they said that, oh, he doesn't even live in Thornton Township. Yeah, okay, he can just prove that with documents of his residence. It was not a complex issue. But for them to want to waste time on putting on a shit show to object to something they could not prove, just to have a complaint, this is what, good grief. This is what stalls government from happening. Why can't they tell Super Stupid to get her dumb ass off that insurance policy so the insurance policy renewal can occur in Thornton Township if she truly cares about the people? She's the one that's causing the insurance to not be renewed. They don't need a vote on that. That's a phone call for renewal. That's a click of a couple of buttons online. You are not insurable, Super Stupid. Why they can't tell her what she needs to be told? And then if she doesn't like it, guess what? What do you owe them? They're useless idiots anyway. This is ridiculous. All it is for them to still determine, no, y'all dumbasses only filed 2 pages. They were improperly filed. They had staples in them. They didn't have a red stamp on it. And you two are still not that smart. You're not attorneys. And this attorney outwitted you with 4 questions that he basically asked in 3 different ways. While Michael Smith still could not figure out how to say either yes or no. And when he tried to say, I do not recall, I mean, it's on the dumbest question. It's like, it's the dumbest statement to give on a question that's simple. The question wasn't dumb. It was strategic. He was like, I'm asking you to recall something you just said 45 minutes ago in a hearing that's being recorded, where we have someone taking minutes, making a record of this. Just ask the reporter who's making a record. It happens in court all the time. May I ask if the, reporter go back 45 minutes and recall what I said? To ensure consistency in my testimony. Because when you start contradicting yourself on the simplest of things, you automatically look like a dumbass liar. Automatically. Now you've lied. You talking about you don't recall what you said 45 minutes ago, unless you have amnesia or you really are a dumb, brainless simp and have the inability to think. That's what it is. Because he can't define the term additional. Okay. He's a dumb, brainless simp. Got it.
Based upon that motion.
She ready to go.
Mr. Smith, do you want to file something in writing requesting to...
The attorney is saying, I want to dismiss this with prejudice so that you don't bring it back up. Because you didn't have any evidence to support your objection in the first place. You didn't even properly file the objection. And then you tried to make it seem as if you didn't have enough time to do it when you did. Waiting 5 minutes for a clerk to come to an office on December 23rd at 3:45 p.m. is not an excuse. It's not relevant. It makes no sense. No one cares. So you had time to file it correctly. You just don't know what the hell you're doing, and you think you can just object and say, here's what it's going to be. And these are simple. This is simple to me. They could have just read the rules and the law on how to file an objection for a nomination to an election board. And they couldn't even do that. How do you think this would go if you had to file this with court? That judge would destroy them. It would be epic. That judge would tear their asses up to bits and then wouldn't let them say 2 words. Biggest size me would not be able to go in there. That loaded baked potato would not be able to go in there and say any of them smart remarks and comments that he always tries to say, because he's not smart enough to come up with anything else. So he has to be condescending. It's all he knows. Well, I don't have a brain to think hard or define the term additional, so let me just be condescending all day and throw out smart comments that don't have anything to do with anything. You have a wife. Go home to your family and tell super stupid to go to hell. Like, seriously. You two have all this loyalty to somebody that is under FBI investigation. Shows how smart they really are. Like, come on. The judge is, the attorney is doing what he should be doing. No, I want a motion to dismiss with prejudice.
That was the purpose of this hearing.
How are our prices?
That was the purpose of this hearing, to drop the residency part of the...
I thought so too.
and you all asked for the evidential...
Clark, yeah. Because, yes, to brilliantly destroy you all. So you can't keep coming back with this dumb shit.
It is definitely noted for the record. It is definitely noted for the record. I guess the board can. I don't. The board can make a decision as it relates to.
Right.
Because they don't like it. They throwing tantrums. Grown ass men throwing tantrums like this. They should be scared of the FBI coming for super stupid, because they're going to be. You think this is something, an evidentiary hearing for an election board. You think this is something. Wait till your ass gets summoned to court once her ass gets indicted and you have to testify in federal court. Good luck to that. Why you still can't define the term additional, any, or other. Good luck to that one. Oh.
Information as to residency is on page 1. And we don't, why do you have 2 hearings on the same subject?
Well, Mr. Swanson wanted to offer something.
Just for the record.
Yeah, I would have asked for it as well. So we're not coming back here on this dumb nonsense anymore. We're going to nip it in the bud.
Deny the motion to withdraw the residency issue at this time. The parties can deal with that issue in the motions that are filed on their...
Just file your motion and shut the hell up is basically what Colonel Sanders is saying. File your motions. Let's go.
This is different. I mean, it's up to the
Well, we
board.
want the motion to make it, but the motion,
I think the board can really do it either way, but, you're placing it however the board wants to do it.
I have an issue with that because.
Why? Because you don't know how to write a motion?
He's gonna file a motion that removes us totally or trying to strike the other, objection that is put forth.
No, he's gonna ask for a motion to dismiss this dumb matter regarding the residency with prejudice because you never had any evidence to support your motion on the objection in the first place. And since you failed to present any evidence to show that there was any viable issue with the residency to begin with, he's trying to make sure y'all don't bring that shit up again. And if you do, nope, this was dismissed with prejudice. It shouldn't show up in a court of law or an election board hearing moving forward because we dismissed that with prejudice. There was no finding of fact or law to support an objection of Napolean Harris's residence. Something he could prove with a mortgage deed. What the hell is wrong with you two? All you got, you can just get a light bill. I mean, what are we talking about here? You objected on his residency based on what grounds? You can't prove he does not live within the district. So what the hell are you talking about? The attorney is doing what he needs to do to make sure we continue to move forward with this crap so they can continue to lose like hell because they don't have any evidence. They can't even file a proper objection. What are we talking about?
I think it is in order for this board.
We're not coming here on this BS no more. I'm going to make sure of it. I'm getting a motion to dismiss with prejudice.
To withdraw whichever part of my objection that I want to. That is by state statute.
No, that is incorrect. Because you don't know the law.
You can request to withdraw, but it is up to the electoral board as to whether to accept that withdrawal.
Wait a minute. Oh, that was epic.
As an objector, to withdraw whichever part of my objection that I want to. That is by state statute.
That's incorrect, actually. That's incorrect, actually. An objector can request to withdraw, but it is up to the electoral board as to whether
we want to accept it or not. Because you don't operate. This is not a dictatorship. You don't operate with full authority.
This board.
Oh, now you're asking. I'm requesting.
The residency portion of this.
And the attorney wants a motion to dismiss with prejudice.
Withdraw the entire objection. Is there enough left of the maybe 30-page missing the section? Do you state anything?
I believe there is something left of the objection for.
Oh, for goodness sake. That's why the attorney is wanting a motion to dismiss with prejudice.
To ask and request of this board that you go with my motion to withdraw the residency portion.
To give a little more clarity to your question, ma'am, the only thing we would actually lose is the portion number 2 where it says caucus participation violations. That's the part.
And they can't prove that with law or facts either. They won't be able to prove that either. Oh, that attorney's going to have a good time destroying their asses.
Rules 1, 4, 5, and 8.
Oh.
We still have that listed on the last page. We also touch on the part about the pre-party before the caucus.
So what? They have the right to have a party. Next. That judge is going to eat their asses up, boy. He's going to shred them to bits. Might take longer with Biggie Mac, but it's going to happen. You're going to get shredded to bits. Shredded to bits.
Specifically meaning caucus day procedures.
Okay, I was just asking because if it helped you just.
She's saying to file your motion and put it in writing. Good grief.
The objection on the
My suggestion is for the board to just take all of this under advisement, have everybody file everything in writing.
Exactly. File it in writing.
Decide all this on the 24th.
That's it.
You stated it very clearly, so that's what I do. We take it all under.
File it in writing. She ready to go. There's enough.
Motion
We're ready to
to take this
go.
all under advisement and decide this on the 24th after full briefing by the parties. Is that a second? Okay.
Under the size of the we haven't already ruled on the
Correct. All in favor?
Aye.
Any opposed?
Finally, homemade manjaro.
All right. I don't think there's anything further with Sue.
She just told him, put it in writing. Stop talking about this. There's nothing to discuss.
That is Keith Price and Michael Smith versus George Baker. Parties, can you please state and spell your names for the record?
Objection. Keith Price.
Okay, so I just wanted to just showcase that portion of the hearing because, you know, the attorney just absolutely obliterates Michael Smith because he didn't want to, you know, think hard about the definitions of the terms any other or additional and didn't know what an objection meant, especially the one that's based on non-responsive or nor did he know how to shut the hell up once an objection was actually rendered. Wanted to still answer the question even though the board has to decide on whether they're going to overrule or sustain it. So they've learned nothing from this. And then they proceeded on with George Baker, you know, talking about how he was not registered to vote and all of that. The double McWhopper over there is not qualified to sit there and study election registration documents. He should not be privy to that information. He certainly should not know when someone has registered or not, or where someone lives, or be looking at addresses. There is nothing that he does that requires for him to even touch those election documents. Period. And I hope that Napoleon Harris Attorney hears that. Keith McChicken does nothing that requires for him to access election registration, voter documentation of any sort. Nothing. They've said in many, many videos that he deals with food pantry, and that's right up his fat ass alley. Right up his alley. Food pantry. That's what you deal with. Food. There's nothing that requires for you to have to touch election rolls or voting registration documentation of any sort whatsoever. And yet, they get to just invade on people's privacy, I guess. And access documentation that they have no right or authority to access. So that needs to be brought up and questioned. And I hope and pray that the day that Super Stupid gets indicted comes swift and quickly. And these two will have to answer to all of this simping nonsense they doing for her as if she's their wife. I mean, they probably spend more time with Super Stupid and bend over backwards for her than their own spouses. This is insanity. December the 23rd, you want something that you could not properly submit to be stamped by a clerk and complain about waiting 5 minutes for it. When you'll wait in line for a gallon of sweet tea for the same amount of time, and kick rocks barefoot. All right, now that Tweedledee and Tweedledum have both been epically destroyed by an attorney, and we're not even a court of law yet, you guys make sure you check out the Critical Smoker. I wanted to make sure I said the right channel. YouTuber that posted this up. He went to the meeting, recorded this, and posted it up. I wish all of the people would have spoken into the mic, but clearly they don't know what they're doing. They're not attorneys, and they think they're so smart. And it's almost painfully laughable. It's not painful in a bad way. It's just laughable to the point where it hurts to see them just put on this utter clown shit show. And Super Stupid sitting in the audience just like, wow, these two goons just, wow, they're dumb. Great. This is a taste of what you're going to get in court. And it won't last this long because no judge is going to put up with their buffoonery. They won't be able to say, he won't be able to go to court and cuss and use profanity because he could be held to contempt and they'll lock his ass up for 72 good hours. You don't know anything about government or the law. And he literally got called out on it, which is why I had to rewind it because it was just too good to hear once. I had to hear it twice. She was like, that is actually incorrect. That is incorrect. You can bring up whatever you want, but it's up to the board to approve it. That is incorrect. You sitting here talking about state statute. He loves saying state statute, but won't cite the code. Won't cite case law. I'm still waiting on you to tell Judge Thaddeus Jones how he signed an injunction and violated the law. Which one again? Which state law did he violate? Come on, you dumb goon. Now, come on, keep pretending like you're an attorney. That should fare well for you in the future. All right. You guys make sure y'all hit the like button and subscribe. This was another lengthy video, but we have fun clowning these two. I have so much fun with it. It's hard to stop laughing over it. Anyway, you guys make sure you share and check out other content. Yes, Super Stupid has her own playlist on my channel. This is also going to be added to the podcast, so you'll be able to listen to this on your way home, on your way to get McDonald's and Wendy's and all that good stuff. Keith Big Mac. And, you know, hopefully this is something informative you guys can learn. I'm constantly reading and researching information. I don't profess to know it all. And I think that's the beauty of being a human being and just ever evolving and learning and growing. You don't need to go through life like you know it all, like you're the smartest person in the room. It's okay to say, I'm not aware of that. Let me look it up. But I had to look up some of these, you know, the objections that they were written. I looked this stuff up. I read something that Super Stupid refuses to do. Or Michael Smith or the other one, Humpback. Y'all refuse to read. Pick up a dictionary or a book and read. And stop accessing people's information illegally. You work in a food pantry. What the hell you need to look at the election roll call and registration documents for? Boy, if you don't kick rocks. All right. Share the video, like it, subscribe. Let's get to 50,000 subs. I want you guys to continue to stay safe, take care of yourselves and each other. Lady Luck out. Deuces.